Welcome back to the Deep Dive. Today we're really getting into the weeds, using Justice Oliver Wendell Holmes Jr.'s famous work, The Common Law, as our guide. And our mission for you, the listener, is pretty crucial. We need to figure out something fundamental in contract law. When does a promise actually bind someone? And when is it, well, just talk? It matters hugely, because getting one word wrong, classifying a condition incorrectly, could mean winning a lawsuit or finding out you never even had a contract. So we're trying to draw the lines between conditions of formation, conditions of performance, and just regular promises. Okay, let's try to unpack this.
Yeah, and Holmes really forces us to be precise here. You can't just vaguely talk about a contract term. You have to immediately figure out its job, its function, because that classification changes, well, everything: who has to sue, what they need to prove, the whole nine yards. So to do this right, we need to make three key distinctions. First, the big one: conditions of formation versus conditions of performance. Second, the difference between conditions precedent and conditions subsequent. That's more about strategy. And finally, we need to look at conditions versus simple promises, which often comes down to practical stuff.
Okay, let's start with that first one, the formation condition, the one that can sort of kill the contract before it's even born.
Hmm.
What's the real dividing line between a condition that stops a contract from ever existing and one that just pauses or ends the duty to perform later on?
Right. It all boils down to power, really. Who's holding the cards?
Yeah.
The general rule for a condition of formation is this: if fulfilling the condition is completely, totally up to the promisor's own subjective choice, their will, well, then there's as yet no contract. There's no obligation. Why? Because they can just change their mind. They can withdraw whenever they want until they actually decide the condition is met. Holmes basically gives us two elements for this. One, the condition is tied to the contract actually starting. And two, crucially, fulfilling that condition is entirely within the promisor's subjective control. If you can just decide later if you feel like being bound, you haven't actually promised anything binding yet.
Huh. That sounds like it could be a massive loophole. Let's test it right away with that classic example Holmes uses, the satisfactory close. The setup is a tailor promises to pay for clothes, but only if they're made to the customer's satisfaction. Hmm. Okay, let's analyze satisfactory close. First up, what are the legally dispositive facts? What really matters here?
Well, the key fact is that the payment hinges on the customer's subjective satisfaction. And specifically, we need to focus on how Massachusetts courts saw it back then. They said the customer was the own final judge. Their opinion was the only one that counted, basically.
Okay, and the core legal issue. What question did the court need to answer?
The issue was, can a promise like that, where one person gets total, subjective, unchallengeable control over whether they're satisfied, actually create a real enforceable legal obligation?
Makes sense. What rule of law did the court apply? Can you state the full rule and maybe break down its testable elements for us?
Sure. The principle they applied, following Holmes, is that if a condition is entirely up to the promisor's personal choice, it doesn't create a legal obligation, so no contract yet. The elements you'd test are: first, is the promise dependent on some event happening? Here, it's satisfaction. And second, does the promiser keep absolute control over that event? Meaning, can they basically just say yes or no based on their own whim?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the idea of the promisor retaining absolute control?
Right. So under that specific Massachusetts interpretation, the final judge thing, the court said, yes, this element is absolutely met. Why? Because the customer could simply declare they weren't satisfied. That was enough. The facts showed they held all the power to decide the outcome, regardless of how good the clothes actually were.
Wow, okay, so the contract is just poof, gone, because the customer holds that veto power. But Holmes brings up another way to look at it. What if the contract meant the close should satisfy a reasonable person or ought to satisfy the customer, making a jury the judge? How does that change the analysis about control?
Ugh, that flips it entirely. If it's about what ought to satisfy someone reasonably, then the customer gives up that absolute subjective control. The decision isn't just inside their head anymore, it's measured against an external standard, something a court or jury can review. The second control is externalized like that. The promise can be binding. It stops being a condition of formation and becomes potentially a condition affecting performance under an existing contract. It's a fundamental shift.
Okay, I see. So looking back at both ways to interpret it, what was the court's final conclusion specifically on that Massachusetts subjective interpretation?
The conclusion was pretty stark. That subjective satisfaction clause, interpreted as depending entirely on the promisor's will, means it's no contract at all. Legally, it's seen as illusory. It doesn't bind the promisor until they voluntarily say, okay, I'm satisfied.
All right, let's shift gears a bit. Holmes also talks about another classic pair, conditions precedent versus conditions subsequent.
Yeah.
This one trips people up sometimes. What's the real practical difference here, according to Holmes?
Yeah, this one sounds more complicated than it often is in practice. While lawyers sometimes make a big deal of it, Holmes points out its main impact is really procedural. It's mostly about the course of pleading in a lawsuit. Basically, a condition precedent is something the plaintiff, the person suing, has to bring up first. They have to state in their complaint that they met the condition to show they did their part and now the defendant owes them something. A condition subsequent, on the other hand, is something the defendant raises. They use it as a defense, arguing, okay, maybe there was a contract, but something happened later that breaks the deal or excuses me. So it really just determines who has to mention the condition first in the court documents.
Okay, that clarifies things. Now let's get to what feels like the heart of many business disputes. How do courts figure out the difference between just a minor promise where if you break it, you might owe some money, some damages, and a really critical condition where if it's not met, the other side can just walk away entirely? This isn't about subjective will anymore.
Right, exactly. We move away from the promisor's psychology and into the world of, well, practical business. The general rule for distinguishing a condition from a promise in this context involves looking at practical considerations. Holmes emphasizes this. The court has to examine two key things. One, the basic nature of the contract itself, what kind of deal is it? And two, the great importance of that specific term or stipulation to the main reason, the core object, for making the contract in the first place.
Okay, before we dive into a case on that, let's just quickly cement that first rule about subjective control. Let's use a quick visceral example for the listener. Imagine you tell someone, I'll pay you $5,000 for that dusty old set of law books, but only if I find the footnotes sufficiently amusing. Is that a contract based on Holmes's first rule?
Nope, not a contract. Finding footnotes amusing is completely subjective. It's entirely personal, inside your head. It's totally within the control of your own will. So under that first Holmes analysis we discussed, you haven't made a binding promise yet. You can still back out until you actually declare your amusement. No obligation there.
Perfect. Okay, now let's apply that second rule, the one about practical considerations and importance, to a real performance dispute. Let's look at the Donskoy wool case. So, the facts are, buyer and seller agree on wool shipment from Odessa. The contract says, critically, the names of the vessels should be declared as soon as the wools were shipped. Now the buyer, the defendant, argues they needed this wool for resale. Its price fluctuates like crazy, and they couldn't sell it until they knew the ship names. The seller, the plaintiff, didn't declare the names on time. All right, let's analyze Donskoy wool. First, what are the legally dispositive facts that the court would focus on?
The essential facts are, you've got this mutual deal. The goods, the wool, have a rapidly changing market value. There's a very specific time-sensitive requirement. Declare the ship names as soon as they're shipped. Both parties knew the buyer's purpose was resale. And crucially, the seller failed to declare the names as required.
And what was the core legal issue the court had to wrestle with?
The precise question was, did that requirement to declare the ship names act as a condition precedent? Meaning, if the seller didn't do it, was the buyer completely excused from having to buy the wool? Or was it just an independent promise, where the buyer still had to take the wool but could maybe sue for damages caused by the delay?
Right. What rule of law did Barron Park and the court apply here? State the rule and break down its testable elements, please.
Okay, Barron Park used that rule focused on commercial reality. The court must examine, element 1, the nature of the contract itself, what kind of business deal are we looking at, and element 2, the great importance of the specific term to the main objective of the contract, especially if both sides knew what that objective was.
Thank you. Now for the court's elemental analysis. Let's break it down. How did the court apply the first element, looking at the nature of the contract?
Well, they really zoomed in on the commercial setting. They noted the wool was an article of fluctuating value. That's key. And they highlighted that the whole point of the purchase, known to the seller, was for the buyer reselling it in the course of the defendant's business. So timing, market access, these were baked into the deal's nature.
Understood. Now what about the second element, the great importance of declaring the ship names to that known business objective?
The court found this wasn't just a minor detail. Declaring the names was critical. Why? Because the wool was effectively not saleable until the buyer knew which ships it was on. They couldn't make deals to resell it, since the whole point, known to everyone, was quick resale in a potentially falling market. Getting those names promptly was absolutely essential to achieving that goal.
Okay, so after weighing the nature of the deal and the critical importance of that declaration clause, what was the court's final conclusion?
Given those practical factors, the need for resale, the volatile market, the court concluded that the promise to declare the vessel names wasn't just a side promise, it was a condition precedent. Because the seller failed to meet that condition, the buyer was completely excused from their obligation to accept and pay for the wool.
This is incredibly useful. So pulling it all together for our listener trying to analyze a contract problem using Holmes's approach, what's the step-by-step diagnostic checklist they can use?
Okay, based on Holmes in these cases, we can boil it down to a three-step checklist for spotting the issues and analyzing them methodically. Step 1. The existence check. First question. Is fulfilling the stipulation purely up to the promisor's subjective whim and their personal will? Think satisfactory clothes. If yes, stop. There's no contract yet, just maybe an offer you can revoke. If no, meaning there's some objective element or the control is external, then a contract might exist, so go to step 2. Step 2. The scope check. Okay, so you have a contract. Now, is this particular term a deal breaker condition or is it just a regular promise? Here's where you look at those practical commercial factors. What's the nature of this specific contract? How important is the specific term to the main known business purpose of the deal, like the ship names in Donskoy wool? If it's essential to the core objective, it's likely a condition. Step 3, the procedure check. Right, if you decide it is a true condition, the last step is figuring out if it's precedent or subsequent. And remember, this is mostly about legal strategy. Who has to plead what in court? Does the plaintiff need to prove they met it to even start the case? Precedent? Or does the defendant need to raise it as a reason why they're excused later on, subsequent?
That's a fantastic framework. It really highlights the incredible weight even a single word or phrase can carry in a contract, whether it's about someone's personal satisfaction or the hard realities of business and timing. And that brings us to a final thought for you to chew on. Holmes, especially in Donskoy wool, clearly values those practical business needs. So how much should courts really weigh what the parties actually wrote down their specific words versus the underlying economic necessities of their situation when deciding if something is a condition? It's a tough balance. In a dispute, should the focus be more on the explicit agreement or on the commercial reality driving it? Something to think about as you look at more contracts.